Dear participants, dear guests, my name is Roman Nikolak. I work as an International Relation Coordinator at Center for Civil Liberties, and I will be your moderator today. If you are new to our platform, I will briefly explain. CCL is a Kyiv-based NGO registered in 2007 and that received Nobel Peace Prize in 2022. We work on issues of human rights, IHL compliance, and international relations. Today, we start Ukrainian Criminal Justice Week, a series of events dedicated to international criminal justice system, ICC, and development of international humanitarian law. This week is dedicated to June 17, International Criminal Justice Day, a series of events that taking place worldwide to commemorate the anniversary of Rome Statute adoption, the work of International Criminal Court in Hague. This year, this our webinar series is co-organized by PLPG, a Public International Law Policy Group, US International Law Firm. Overall, we will host two webinars today and tomorrow at 5 p.m. Kyiv time. Today, the webinar is dedicated to environmental law and violation of environmental law. And tomorrow we will speak about the definition of crime of aggression, ICC, and Kampala amendments. After approximately a 40-minute lecture, you will have a 15-minute space to ask your questions, either in a chat in writing, or you can raise a hand and voice your question for yourself. Our previous webinars are also available online at our YouTube channel, and I will gladly share it with you in the chat. This video though will also be recorded. If air alarm occurs during the lecture, please seek safety. You can disconnect and look for the nearest shelter. And don't worry to miss out, because this webinar will be recorded and it will be placed on our YouTube channel, and you can revisit it for your educational academic purposes. Today, our speaker is legal scholar, Professor Michael Kelly, who works at Creighton University, where he directs the Cayman Center for International Criminal Justice and Holocaust Education. He also do pro bono work through PLPG, based in Washington, and International Bar Association, based in London. With this work, he currently supporting Ukrainian prosecutors in investigating and prosecuting environmental crimes committed during Russian war of aggression. And today he will explain to us what is the definition of environmental crime and how it should be prosecuted, investigated. So, Professor Kelly, the floor is yours.
Thank you very much, Roman. It's nice to be with you all today. And let me say, I support your resistance to the Russian aggression 100%. I had the pleasure of coming to Lviv in 2023 for the American Society of International Law Summit with the Ukrainian International Law Association. And then I came back last year up to the border to do some trainings with Ukrainian prosecutors on how to bring environmental crimes. And I've been impressed consistently with the resilience of the Ukrainian people year after year of this aggression. So I applaud you and I support you and I honor your work. And I want to keep contributing as much as I can to all of your efforts. The recent contribution and the subject for today's talk that Roman scheduled me for is environmental crime. And environmental crime has been gaining traction as a basis for prosecution, mostly under international law. Ukraine is actually pretty far out ahead of the rest of the countries of the world with respect to domestic prosecution in a couple of ways that I'll get into. But one of the things that we found most interesting when we spent time with your national and regional prosecutors was the seriousness with which they took their mandate from President Zelensky to actually stand up cases and present evidence, preserve evidence, and pursue prosecutions based on environmental crime, not based on war crime or a crime against humanity as a version of environmental crime, but try to put that into the forefront of the case, which I think is very forward-looking. The team that I worked with was led by Paul Williams and Michael Scharf, the co-directors of PILPG, Milena Stereo, the managing partner, and Meg de Guzman, a judge at the former Yugoslavia tribunal, now known as the Mechanism. And one of the things out of all the different cases that we discussed that we found most surprising and didn't really know a lot about was the crime of Russians and the Russian Navy killing dolphins in the Black Sea during this war as part of its environmentally devastating military aggression against Ukraine. The Navy's indiscriminate shelling, mining, and aggressive use of sonar has wiped out between 1/5 and 1/6 of the Black Sea's cetacean population, which consists both of dolphins and porpoises. This is an environmental crime. A 2023 study conducted during a 3-month period found that between 37,500 and 48,000 of these animals have perished out of a population of 250,000 due to war-related injuries, amounts egregious enough to actually cause an extinction event as the war continues. Even Russia's land-based attacks on Ukrainian civilian infrastructure, in and of themselves war crimes, exacerbate dolphin casualties. The destruction of the Kakhovka Dam sent trillions of gallons of polluted water down the Dnipro River into the Black Sea, flowing out into the dolphin population near Odessa. And it's the regional prosecutor in Odessa who's actually investigating this case and will eventually bring it to court. So, there are some surprises even for old international attorneys like ourselves of what we will find. The array of other environmental crimes that have been unleashed during this war of aggression by Russian forces include burning forests, polluting waterways, mining environmentally protected areas, littering sunflower fields and wheat fields with unexploded bombs. Indeed, almost 1/3 of the land in Ukraine is now contaminated with unexploded ordnance or bombs. So how do you pursue an environmental crimes case if you're a prosecutor in Ukraine and you're trying to figure this out? There are two pathways under Ukrainian law. One is charging environmental crime as a form of war crime, or the second one is charging it as ecocide. The Ukrainian code provides for either of these pathways, but both entail their own distinct pros and cons. Environmental crime as such is emerging as a distinct focus of accountability in The Hague, as well as in Kyiv at the International Court, the International Criminal Court. So on the international side, the ICC issued in February 2024 a call for commentary on the court's ability to define, investigate, and prosecute environmental crimes as crimes within its jurisdiction under the Rome Statute. Prosecutor Karim Khan stated that damage to the environment poses an existential threat to all life on the planet. For that reason, I'm firmly committed to ensuring my office systematically addresses environmental crimes in all stages of its work, from preliminary examinations to prosecutions. And so the path generally of pursuing environmental crime is happening internationally as well as domestically. The question is, which road would you take? The modalities on the international side of the equation typically come from crimes against humanity, war crimes, or possibly aggression. The Rome Statute itself does not have a separate provision for ecocide, although an effort to amend it in this way was offered at the 2024 Assembly of States Parties. Ecocide has been defined at the international level as, quote, unlawful or wanton acts committed with knowledge that there is substantial likelihood of severe and either widespread or long-term damage to the environment. The proposed amendment was not adopted. It would have created a fifth crime under the jurisdiction of the ICC. The states, there was support though for it. It wasn't shut out completely, which tells me that there probably at subsequent meetings of the Assembly of States Parties, you might see this effort come around again. The arguments in favor of adding ecocide to the Rome Statute include a possible deterrent effect. Proponents argue that criminalizing ecocide at the international level would act as a strong deterrent against it being committed. The relationship to existing law, some have said there's a gap in the Rome Statute, such as in Article 8.2b, Roman 4, that have limitations that have not effectively been used to prosecute environmental crimes. Environmental protection itself, of course, accountability. Climate action is another reason offered for amending the Rome Statute to include ecocide. Arguments against including it include some of the legal challenges that the definition would raise, potential difficulties in proving intent and causation, political hurdles, getting it adopted through the ASP, and then that process leading into transposition of it becoming an effective component of the Rome Statute. We saw this kind of migration happen with the crime of aggression when that was finally adopted at the Assembly of States Parties, and then how that kind of morphed into a thing in the Rome Statute that could be used with certain bookends around it that really crimped when it can be deployed by the prosecutor. And then, of course, there's always enforcement issues with respect to the ICC. So that should come as no surprise. The other thing that's happening at the international level is the question of including environmental destruction as a crime against humanity. Some of you may be aware that there is a treaty underway at the International Law Commission. It's part of the United Nations process coming through the committees to criminalize crimes against humanity. Currently, there is no treaty on crimes against humanity. There's a treaty on war crimes. Of course, that's the Geneva Conventions. There's a treaty on genocide, but there's no treaty for crimes against humanity. And so this effort to fill that hole is in process right now. And one of the debate points is whether or not environmental destruction should be listed separately as its own crime against humanity. Currently, it's not. If you look at the definitions of crimes against humanity in the Rome Statute, in the Yugoslavia Tribunal Statute, any of the organic definitions in the international criminal tribunals, that's left out. Now, you could read into it as other acts that constitute crimes against humanity of similar gravity, and as long as they meet, the widespread and systematic components and of the actus reus and the mens rea of intent, then you could argue that environmental crime should be prosecuted. Perhaps one model a couple of years ago was the case of the destruction of burial mounds in Timbuktu in Eastern Africa. Again, cultural protection was not specifically listed as a separate component of crimes against humanity. Nevertheless, it was prosecuted. However, those who are arguing for its inclusion, and I'm one of them, have looked at definitions that don't really embrace the ecocide definition. They really comport more with crimes against humanity itself. And so if this new treaty is going to have a provision, that definition would look something like widespread, long-lasting, or severe destruction of the environment, including biodiversity, natural resources, agricultural production, or landscape as a means of harming any civilian population. The first component, widespread, long-lasting, or severe, those are classic components when we're talking about environmental destruction or habitat preservation. The examples that we lay out, biodiversity, natural resources, or landscape, also are classic ones. My experience with Ukraine caused me to really argue strongly for inclusion of agricultural production as part of the environment that needs to be protected, because so much of what Russia has done in its war in Ukraine is destroy your agricultural production. And if that's not included as part of the environment, it can't be prosecuted as an environmental crime. And so I'm a big advocate of including that. And then as a means of harming any civilian population. The thing about crimes against humanity is that it is only designed to protect humanity. It's not designed to protect other things. And so here, implicitly, you have to really understand that if an entity harms the environment for the sake of harming the environment, or for some other purpose than harming humanity, then it wouldn't be included. The civilian population is always the focus when we're talking about crimes against humanity. From an application standpoint, unfortunately, that last part could mean that multinational corporations in the extraction industry that damage the environment severely as they're pursuing oil production or whatever, they could not be prosecuted for environmental crimes as a form of crimes against humanity under the treaty, because they wouldn't be trying to harm a civilian population in the process. So those are kind of the movements on the international stage that are currently underway. There's broad agreement and growing agreement internationally and within Ukraine that environmental crime as such should be prosecuted. But the choice that your prosecutors have to make in your national courts on whether to do so as a war crime or as ecocide is open both paths. Again, they have their own advantages and disadvantages, chiefly on the war crime side. If you try to prosecute it that way, there are very strong defenses grounded in military necessity that must be overcome. On the ecocide side, if you choose that path of prosecution, inexperience, frankly, with this kind of prosecution, coupled with high hurdles under Ukrainian law to prove causation, which needs to be very specific and very direct, have to be overcome. Either way, however, Ukraine stands poised, really, I think, to make a lasting contribution to this important legal conversation, because you're going to be doing something that the rest of the world is not yet. And so I understand that in public international law, while there's no precedent for cases, there is precedent for practice. And Ukraine can really be a leader in this process because of that. So let's just take a little bit of a look at the Ukrainian Constitution and the Ukrainian Code that would come into play if prosecutors and courts are going down this road. The provisions in the Ukrainian Constitution and within the criminal code itself can't really be discussed without also talking about bringing in those international law provisions that I was just discussing. Article 9 in the Ukrainian Constitution provides that international treaties that are in force, such as the Rome Statute, and agreed to be binding by your parliament, the Rada, are part of the national legislation of Ukraine. So these treaties are binding force, binding legal force within your legal framework. That's Article 9. Article 18 says that the foreign political activity of Ukraine is aimed at ensuring its national interests and security by maintaining peaceful and mutually beneficial cooperation with members of the international community, according to generally acknowledged principles and norms of international law. Thus, Article 9 makes international law Ukrainian law, and Article 18 mandates that Ukraine adheres to internationally recognized principles and norms, which include obligations under IHL, or international humanitarian law. International treaties that have been ratified have the same status as Ukrainian laws. If a treaty conflicts with national legislation, the provisions of the Constitution will prevail, thus providing some kind of a hierarchy here. Consequently, there are two intertwined for purposes here, deciding between prosecuting Russian defendants on the basis of environmental crime as a species of war crime or prosecuting them on the basis of ecocide. The discussion has to include international legal touch points either way you go. So importantly, either path will be informed by that. Environmental crime as a war crime. Let's talk about that first. The international components that your Constitution brings into play for a prosecution to consider start with Article 438, violation of the laws and customs of war. This is where your Ukrainian criminal code reaches out and kind of has a relationship with the Geneva Conventions. Article 438 discusses cruel treatment of prisoners of war, civilians, expulsion of civilians for forced labor, etc., premeditated murder, and this incorporates all of the components of the Geneva Conventions. If we bring that into play with the Rome Statute, Article 8, 2b, Roman 4, intentionally launching an attack in the knowledge that the attack will cause loss of life or injury to civilians, widespread, long-term, and severe to the natural environment, that would be clearly excessive in relation to concrete and direct overall military advantage. The additional protocols to the Geneva Conventions, specifically Article 55 of Additional Protocol 1, says care shall be taken in warfare to protect the natural environment, again, against widespread, long-term, and severe damage. This protection includes prohibition on the use of methods or means of warfare which are intended or may be expected to cause such damage to the natural environment and thereby prejudice the health or survival of the population. We can look at the Hague regulations from the turn of the 20th century. We can look at INMOD, the Convention on the Prohibition of Military and any other hostile use of environmental modification techniques. INMOD was adopted by the Soviet Union in 1978, and therefore Ukraine, as a successor state, belongs to it. The Convention on Biological Diversity, and of course, finally, the United Nations Framework Convention on Climate Change. So one of the main drawbacks I alluded to earlier and trying to go for a prosecution of environmental crime as a form of war crime is that the defendant may raise a military necessity defense. This is a potent defense, and it can really frustrate a successful prosecution if it is grounded, well-grounded in a particular battlefield facet, and if the decision of the commander to undertake the attack that resulted in the environmental destruction is deemed reasonable. So ICC jurisprudence considers destruction of an enemy's property to be justified if it was required for the attainment of a military purpose and otherwise in conformity with IHL. So IHL can literally kind of reach in and rob the Ukrainian prosecutor of the abilities to successfully mount an environmental prosecution as a form of war crime. The destruction and seizure of an enemy's property are allowed under IHL, so long as such measures are necessary to accomplish a legitimate military purpose, which can be to weaken the military capacity of the adversary. So that you have to kind of put yourself as the prosecutor in the mindset of the Russian commander. And what would the Russian commander have known or done, or what challenges is the Russian commander facing, or what natural environmental context is the Russian commander operating in? A forest context, a maritime context, open fields, mountains, etc. So the standard of necessity required is quite high. For example, a commander may undertake a measure involving the clearing of sections of trees to set up a camp in the only militarily safe location, maybe on top of a forested hill, which could be considered necessary. Necessity is often regarded as what the commander in the field assessed the case to be, which is a much more subjective determination than, for instance, what the commander back at headquarters might more objectively consider to be necessary, perhaps because that headquarters commander has more information. One way to blunt this defense is to demonstrate that the Russian commander, when ordering direct or foreseeing indirect disproportionate environmental destruction in furtherance of achieving a valid military objective, knew that the destruction would occur in an environmentally protected area. So Ukraine is fortunate in this regard, in that the Ukrainian Natural Resources and Environment Ministry, every few years, maps all of the environmentally protected areas across your country. This is known as the Emerald Network in Ukraine. And whether it's the aquatic areas in the Black Sea or the forested areas or the national parks or forests, as of 2024, it's estimated that 30% of Ukraine's environmentally protected areas, and there are publicly available maps out there to show these areas, have been adversely affected by the war. Not the least of which includes Russian forces you've heard about absconding with endangered species of plants and animals from biospheres, such as in Oksana Nova, and stealing them and taking them back to Russia. A prosecutor would argue to the court that one may presume a Russian military commander at the strategic level, possibly at the tactical level, but certainly at the strategic level, would have these maps of environmentally protected areas in Ukraine and would know if they are operating in those areas. And so, especially with respect to terrain, like I talked about, chopping down a forest to set up a military camp, you would know that you are disproportionately destroying an environment to achieve a military objective. And so the argument would proceed to the next logical step, that one may also presume those commanders to have knowledge of environmentally protected areas. But remember that Ukrainian courts insist on prosecutorial demonstration of direct causation, which often mixes with the mens rea element. And this is, again, a very high standard. Again, you've got some components of the war crimes angle that have to be worked out. Nexus with an international armed conflict, of course, the perpetrator launching the attack, The attack must cause widespread, long-term, and severe damage. Um, Again, these elements are going to change depending upon what component of the environment is hurt. Widespread, again, that is going to depend upon whether or not this is a habitat, let's say for wildlife. Is 30% of the habitat damaged? Is that widespread enough? Does it need to be 50%? Again, these are new things that need to be worked out. Long term, how long does it take? A drained reservoir behind the Kakhovka Dam, once a new dam is put up, to replenish itself. If that takes 2 years, is that long term? How long does it take trees to grow back that have been burned out of a forest? Maybe 20 years. That's certainly long term. But maybe if it's a fast growing tree, it's not. And then severity. Again, these are kind of subjective requirements. But again, that's going to be the discussion and a point of contention between the defense lawyer and the prosecutor that the judge will have to weigh in on. And science, I think, will come into play very heavily in all three of those. You're going to have scientific experts who are going to be testifying both for the prosecution and the defense on whether or not something is widespread, long-lasting, or severe, depending upon the context of the environment that's hurt. The damage must be clearly excessive in relation to that military objective I talked about. The military objective has to be concrete. The perpetrator has to launch the attack intentionally or in the knowledge that such attack will cause damage to the environment. Again, that's the mens rea element. And then you've got other components of the Rome Statute that would come into play, again, because this is part of your law now. The natural environment being protected as a civilian object, the natural environment being protected as enemy property once it's in occupation. So Russian forces are in occupation of large swaths of Ukraine right now. And as an occupying power, they have a duty, a fiduciary duty to the people living in those lands not to destroy property and not to destroy the environment because they're in occupation of it. Are the Russians doing this? I don't think so, but they have a legal obligation as well. Prohibition, of course, against pillaging. This certainly comes into play with respect to agricultural components and other components. The question of ecocide is again another one where Ukraine can emerge as a leader. Article 441 of the Ukrainian Criminal Code provides for prosecution on the basis of ecocide. It says that mass destruction of flora or fauna, poisoning of the atmosphere or water resources, as well as committing other actions that may cause an ecological disaster, shall be punishable by imprisonment for a term of 8 to 15 years. Now, what counts as an ecological disaster? Again, that's going to be a very heavily laden science argument, and the way that Article 441 is written is that the ecological disaster need not have happened yet in order for the prosecution to go forward. You can start the prosecution and the ecological disaster doesn't need to be completed yet. 441 only says that may cause an ecological disaster. So there's a little bit of wiggle room there in that standard. As with the case of Article 438, one of the drawbacks of Article 441 is its generality. And your judges in Ukraine don't tend to like generality. They tend to like specificity. And so it's up to the prosecutor to really make this specific. For example, this would apply to the concept of mass destruction of flora or fauna in an ecocide prosecution. Since it's not clear at what stage of damage flora or fauna can be considered destroyed, and there's no quantitative criterion that would constitute mass destruction, This requirement is rather challenging to prove. This would also apply to the concept of poisoning the atmosphere or water resources. Um, so the burden is there, and it's on the prosecution to show. And so this would be, one of the stronger areas for defense counsel to try to raise a defense. As with war crimes, international activity on ecocide will be brought in to inform the Ukrainian position, again, due to Article 9 and 18 in the Constitution. Um, and one of the major steps towards the adoption of adequate legislation to address environmental crimes is this proposed definition of ecocide that I gave to you at the beginning of my presentation. Unlawful or wanton acts committed with knowledge that there is substantial likelihood of severe and either widespread or long-term damage to the environment. So you notice that switching out of or from and. In the previous articulations as a war crime, it's and. Here it's or. Um, again, we don't know where this is going to go on the international stage. This is really just beginning to move, which is why international law as such gives us a framework, but it doesn't really give us a firm roadmap yet as to where Ukrainian prosecutors can go. It just really sort of points the way. So when we compare these two pathways under Ukrainian law, either doing environmental crimes as a war crime or doing environmental crimes as ecocide, direct intent is a key aspect of Ukrainian law, which prosecutors have to deal with successfully to bring a case. Direct intent refers to a situation where a person is aware of their actions and consciously aims to bring about a specific illegal result. This is one of two types of intent, the other being indirect or eventual intent. Indirect intent occurs when a person foresees the possibility of harmful consequences and does not actively seek to keep those from happening. So you have to have awareness of the consequences, you have to understand your actions, and you have to desire to achieve the result they want or seek to bring about that harmful outcome. So, for example, if a person sets fire to a building, knowing that people are inside and their goal is to cause the death or destruction, this would be classified as direct intent under Ukrainian law. The Criminal Code codifies this at Article 24, which distinguishes between direct and indirect intent. And it's essential for prosecutors to succeed. Other key aspects that prosecutors trying to bring environmental cases need to lock down include with respect to the perpetrator. Generally, this is some evidence of the Russian commander giving an order to commit the actions that lead to the environmental destruction. The victim includes the object of the environment. And if it's not specified in Article 438, you're going to look to applicable and relevant treaties like the Geneva Conventions or customary international law. And then the armed conflict in the Tadic test from the old Yugoslavia cases provides a framework for determining whether a situation qualifies as an armed conflict. So you take Article 438 and you take Article 441 and you compare them in the Ukrainian Criminal Code as a Ukrainian prosecutor when you are presented with a set of facts and a context and a commander to prosecute. Now, a lot of these prosecutions are going to be in absentia prosecutions because the commanders, you don't really have many in custody. You have a lot of the soldiers in custody who you can turn into witnesses to tell the court what they were ordered to do by their commanders, and that's important. But the commanders themselves, you don't really have your hands on them. So in absentia prosecutions, while not common outside the civil law world, are more accepted in the civil law context, such as Ukraine. Ukraine's efforts to hold Russians accountable for the environmental destruction they've wrought since the aggressive war they commenced in 2022 at the end of the day, does track international legal efforts to define and prosecute environmental crimes as such. But again, whether they're done on a war crimes footing or an ecocide footing is a choice for the Ukrainian prosecutor to make. And the facts are going to help you drive that. Even though you do have this in absentia hurdle to mount, robust defenses can be offered that really kind of lend credibility to the prosecution. I would say at the end of the day, the international tide has turned against perpetrators of environmental crimes. And this includes the Russians in the war against Ukraine. The more accountability for environmental destruction that can be achieved by both international courts and domestic courts, whether as a war crime or as ecocide, is going to make us all better off in the world. And this is Ukraine's moment to really become a leader in this area of criminal prosecution. So thank you for your attention. And Roman, I can answer questions now if you like. I'm a little bit over my allotted time.
Mr. Kelly, thank you for this interesting overview of legislation and your opinions on that. And we indeed receive various questions in the chat, and I would like to offer the following 15 to 20 minutes to tackle them. I will read them, but dear participants, if you would like to voice your question, to give extra argument, please do it, because maybe the text is not enough. If I may, I will direct you to Yaroslav's question. How will Russia be held accountable to Ukraine for war crimes in the International Criminal Court? How will this be regulated between the parties?
Okay, so yeah, the International Criminal Court, it's an interesting venue. It's a tricky venue. Um, there's obviously a lot of procedural hurdles at the ICC. The ICC can build a case and issue arrest warrants, as it has done against Russian commanders, including the president. But they can't really begin a prosecution unless they have the perpetrator in custody. This is different from Ukraine. Ukrainian national courts can begin a prosecution without the perpetrator in custody because you allow for in absentia trials. So you can move forward ahead of the ICC in that regard. That's not going to stop you from doing it. It's a political question, I suppose, for your prosecutors and your judges, and indeed your government. If you're going after the same, Russian commander, the ICC has an arrest warrant out, and the Ukrainian national courts have an arrest warrant out, and the ICC can't proceed because he's still in Moscow. But you can. Does the Ukrainian national prosecutor want to get out in front of the ICC prosecutor and possibly, you know, um, go for the same evidence and struggle, back and forth as to who has the evidence? Or will there be more of a cooperative approach, a sharing approach? Currently, there's a sharing approach. The ICC is sharing its evidence with Ukraine. Ukraine is sharing its evidence with the ICC. That's because the current prosecutor at the ICC and the current president in Ukraine, Zelensky, have a cooperative arrangement. If you have a new prosecutor at the ICC and if you have a new president, there's no guarantee that that cooperation will continue. So these are, I suppose, Roman political questions to a legal problem.
Thank you. I understood. And we have a big opinion and a big question about how crime of aggression influence the environmental crimes, and I will read it aloud because the argument should be voiced. If I understood it right, you are saying that the argument of the defense could be that the attack on the environment was a military necessity, which is the valid and strong argument. But could you please clarify if this apply in case when Russian aggression was illegal under the international law at the first place. What I mean is that if the Ukrainian commander needs to cut forest trees for the defense, it seems clear and necessary. But if Russian one needs to do it, is it still justified under IHL, or you have other opinion on that?
Right. Yeah. I understand what you're saying. This is an illegal war under international law. Nuremberg set the precedent for crimes. They called it crimes against peace back in 1945, 1946. We know it today as aggression. But it is illegal under the UN Charter, and it certainly is illegal under international law. That said, it still is an international armed conflict. And so because it's an international armed conflict, it's regulated by the Geneva Conventions, even though it's illegal. And so you have these defenses available for the defendants, and your criminal code provides for that, just like international law provides for that. And it's up to the lawyer for the defendant to take advantage of the strongest arguments they can take advantage of. They have a duty to present these arguments. Now, how far they will go with a Ukrainian judge is anyone's guess. I mean, the illegality of the war is lurking in the background of that judge's mind. That judge has some experiences probably during these 3 years with the war. I know some of your Supreme Court judges have even been assassinated during this war. So, I don't know that you can totally be objective in that regard. Nevertheless, the defense is there to be raised, and I think it will be. That's one of the attractive components of going at this as a form of ecocide, because they don't have those defenses in an ecocide prosecution. So, that in some ways, depending upon, the facts of your case, that might be a better way to go. One of the biggest questions, I think, that's going to come along, and one of the biggest cases, is the destruction of the Kakhovka Dam. And Roman, I'm sure all of your attendees know all about the destruction of the Kakhovka Dam. That's a war crime, but that's also an environmental crime. And it's mixed. And so, are you going to pull these strands apart and bring separate prosecutions, or are you going to bring a big prosecution under one heading or the other heading? Because there's so many components of it. Not only is the dam destroyed and people died from the flooding and the villages, and the reservoir was drained, and landmines because of the flooding were washed out into the forests. And so now you have all of these landmines scattered everywhere because of the flood, and no one knows where they are, and they're still armed. And their, wildlife are exploding because they're walking over landmines. Those are environmental crimes, but those are also war crimes. And so which way are you going to go on this, as a prosecutor, or are you going to break it down into multiple cases? Keep it as one big case or break it down into smaller cases?
Yes, thank you. And I also receive a question during the registration process, which is quite relevant. Do you think that the international legal community is ready to recognize environmental destruction in wartime as a crime in its own right, rather than just a consequence of war? Would this advance legal accountability, or would it risk to be a politicizing issue in already a fragile legal framework?
Yes, I think the international community is ready. And the key indication for me is that you actually see legal definitions moving around now in all of those documents that I cited at the beginning. And The Hague receiving a first round of comments and now a second round of comments about it. I think we're ready. This conversation, though, is not a new conversation. It's actually a quite old conversation that really began in the 1970s with the American war in Vietnam and the use of napalm defoliant to destroy huge swaths of jungle in Vietnam, trying to fight the war there. Those were devastating components of our military strategy. And environmental crime began to be talked about during Vietnam in our use of napalm. And then it was really raised again in 1990 when Iraq blew up oil wells in Kuwait as the Iraqi army was fleeing in 1991 from American forces. That was an environmental crime. The skies were black. There were fires everywhere. Now, was that military necessity to cover the retreat of the Iraqi army? Or was it just destruction of the Kuwaiti economy on its exit from Kuwait out of just sheer malice? So the conversations have been happening, but it hasn't really been until the last 3 or 4 or 5 years or so that it's gotten serious. And we actually have language being offered at meetings of states and considered, not adopted yet, but considered. And so that's real progress. So I think the international legal community has an appetite for this. How long it's going to be, I have no idea. Again, that's the political side of the question.
Yes, thank you. We have very recent question about in case if the initiative to add ecocide as a fifth international crime under the Rome Statute, do you think it is going to be effective in any way for the case of Russia-Ukrainian war? There is already a gray area to bring Putin responsible for the war of aggression, and Russia is neither a part of Rome Statute uh, nor the amendment to the crime of aggression. I think there is no doubt Russia would not ratify the amendment for the ecocide as well. If, of course, it is ever ratified by two third parties of the Rome Statute with the political fragmentation we currently have. Do you think there will be any practical outcome for the environmental crimes in Ukraine?
At the ICC level, possibly. If there's accountability for Russia on environmental crime in Ukraine at the ICC, it's most likely to be as a form of war crime. Russia cannot be indicted for aggression because of the components of the aggression definition require you to be a state party, and so the prosecutor can't use that. It's not really part of genocide yet. I mean, you could show that the Russian destruction of the Ukrainian environment was meant to bring about the destruction of the Ukrainian people, but genocide requires dolus specialis. You have to intend to destroy the Ukrainian people because they're Ukrainian and for no other reason. And that's a very high mens rea hurdle, which is why you don't have a lot of genocide prosecutions. That leaves either crimes against humanity or war crimes. And of these, I think war crimes is the most realistic. Ecocide hasn't been adopted yet in the Rome Statute. If it were adopted, could Russia be prosecuted for ecocide? Theoretically, yes, if the adoption of a fifth crime of ecocide in the Rome Statute did not include the same restrictions as aggression. If they include the same restrictions as aggression, that it has to be a state party, then you couldn't do it. But if it's free from that, if it comes in on its own, then theoretically, yes. But you run into a problem here in customary international law of ex post facto prosecutions. You can't prosecute someone for something that they didn't know was a crime or that wasn't a crime when they did it. And currently, ecocide is not a crime under the Rome Statute. So it would have to be for probably any other ecocidal activity that Russia undertook from the date of adoption of ecocide into the Rome Statute forward. They don't tend to look backwards prior to adoption.
Yes, understood. And to balance our questions, I will ask another question from Google form. Given the complexities of international prosecutions, what are the major legal and evidentiary challenges in pursuing environmental crimes charges during war crime, especially when the crime scene are inaccessible or ongoing. How can Ukrainian investigator or international prosecutors overcome issues of attribution, intent, and proportionality in such cases?
Yeah, the evidence has to be very specific. And so, drone footage of Russian forces burning forests, and it's clear, that that's who's doing it. Polluting rivers, releasing toxic substances, for instance, from Zaporizhzhia nuclear power plant into a stream that then pollutes a lake, that then kills wildlife or causes agricultural production to be poisoned. That chain of causation has to be strong, which means you need to document it, which means you need to use your drones, or you need to go out into the field and have impartial, non-governmental organizations chronicling what's happening. So, if you have an NGO that's willing to go out into the field and document, Russian crimes of aggression, those are admissible under the Ukrainian code. The prosecutor just has to, cement them into the foundation of the case, proving direct causation or proving the point. And if it's an NGO that is a scientific organization, like Doctors Without Borders, as opposed to an advocacy organization, the Ukrainian judge is going to consider that evidence much better because it's based in science as opposed to advocacy.
Professor Kelly, thank you. You were very generous with your time and answering our questions. Maybe I will ask the final one from Anastasia about nuclear power plants. In your opinion, can the destruction of nuclear power plant be also considered as an ecocide or environmental crime, considering their vulnerability despite IHL protection, and which destruction to environment nuclear energy may cause? So under current legal framework, the potential future destruction of nuclear power plant, how it will be qualified?
Yes, I think the risk of radiation exposure would qualify it as ecocide. The meltdown of the Chernobyl nuclear power plant could have been, considered back in 1986 an environmental crime. The cover-up could be part of that environmental crime as well. And in fact, under 441 in the Ukrainian Criminal Code, that environmental devastation language, radioactive release definitely may cause that level of environmental destruction. And so I think it fits neatly within your language that you currently have in the Ukrainian Criminal Code. On the international level, they don't have a whole lot of experience with it, so I don't know whether it would qualify or not. But I think definitely under Ukrainian law.
Yes, I hope, dear participants, I hope you heard your answers. We are grateful for your time and for your active participation. And Mr. Kelly, thank you for this. Thank you for this beautiful 1 hour dedicated to international law.
Thank you, Roman, and thank you, everyone. Keep up the fight.
Thank you.